Juris Vodcast with Scott Pearce.
The California Supreme Court just issued a ruling that's favorable to employees. The case is called Edwards versus Arthur Andersen. The plaintiff was an accountant for Arthur Andersen. The company quit doing business in America after being discredited by the Enron case. Edwards wanted to get a job. Andersen demanded that Edwards sign away any claims he might have against the company. In return, Andersen was prepared to release him from the non-compete clause in his contract. Edwards filed suit rather than sign. Justice Ming Chin wrote the decision. He wrote, quote, "An employer cannot by contract restrain a former employee from engaging in his or her profession." Close quote. This decision doesn't get rid of all non-compete clauses. There are 3 statutory exceptions to California's rule. California allows non-compete clauses when they are part of a sale or dissolution agreement involving a corporation, a partnership, or a limited liability corporation. California is hostile to non-compete agreements, but much of the rest of the nation also interprets them narrowly. For example, see the 2006 Eighth Circuit decision in DCS versus Castillo, in which Nebraska's law is interpreted in favor of an employee. Because the non-compete clause was too broad, the Eighth Circuit agreed with the employee that it should be void. Workers have not won a lot of rounds in court against corporate America. This is one reason why the distribution of wealth has become so out of balance. This California Supreme Court decision won't solve that problem. But in a small way, it's still good news.
Juris Vodcast is a production of Nuclear Podcast. Creative Commons Attribution, Non-Commercial, No Derivatives.